By my late 20s, I could identify three kinds of lies by the shoes attached to them. Loafers delivered casual lies, Oxfords delivered expensive lies, patent leather delivered lies that expected applause. I worked at Core Inc., a logistics software company that loved phrases like visionary alignment and fearless execution, which were usually code for somebody important cutting corners with excellent posture. My title was Strategic Operations Manager. My actual job was preventing executives from turning ambition into litigation. I liked my work. I liked cap tables, board decks, contracts, and any sentence beginning with subject to review. I liked the neat thrill of catching a risk before it became a headline. My mother said I had a romantic streak for documentation. She was not wrong. I believed in records the way poets believe in moonlight. Then my boss, Ryan, invited me into a glass conference room sometime in the early morning and handed me a draft acquisition memo with the cheerful calm of a man passing along a casserole. The target was a boutique commercial property analytics firm called Slate Harbor Systems. The name sounded trustworthy. So do many poisons. Ryan wanted me to polish the memo for the board. He also wanted me to delete a section describing a title defect attached to one of Slate Harbor's warehouse parcels and remove a note about a trust dispute involving the late founder estate. He called it distracting noise. Noise, in his dialect, meant facts. I asked whether outside counsel had cleared the issue. He smiled the way men smile when they have mistaken a younger woman for a hallway mirror. Leah, he said, the board wants momentum, not a seminar. Boards deserve both, I said. Momentum without disclosure is just speed with nicer stationery. His smile thinned. I took the memo back to my desk and did what he had hoped I would not do. I read everything. The title issue was worse than he had admitted. One parcel had a recording problem tied to an old transfer. Another sat inside an entity whose ownership chain touched a family trust that had not been properly updated after the founder died. An unsigned amendment was floating around like it expected the law to reward confidence. It does not. Deeds are not horoscope entries. Trusts are not family wishes with letterhead. If the board approved a deal without seeing those risks, Core Inc. could face lender trouble, shareholder claims, and a very public lesson in fiduciary duty. I wrote a calm memo to legal and copied Ryan. No fireworks, just facts. Material title exposure, trust and estate uncertainty, possible disclosure failure, need for independent review before board action. I footnoted every point like I was laying bricks. By lunch, my memo had made its way across the executive floor. By afternoon, I had been removed from the deal team. A folder I needed suddenly became restricted. A meeting invite disappeared from my calendar. My year-end bonus was described as under administrative review. Nothing says healthy corporate culture like punishing the person who brought a flashlight. Rian found me near the printers and kept his voice silky. You embarrassed me. No, I said. I documented you. He gave me a long look. The kind that calculates future damage. That evening, a recruiter I barely knew messaged me to ask whether I was all right. Apparently, someone had mentioned I was brilliant but unstable under pressure. I almost admired the efficiency. Ryan was not just trying to sideline me, he was building a soft landing for my reputation before throwing it off the roof. I went home, changed into old sweatpants, and opened my laptop. I did not forward work files to a personal account because I enjoy being correct, not unemployed. Instead, I created a careful chronology using approved systems and my own notes, dates, drafts, meeting summaries, version histories. I saved document metadata and logged each retaliatory action. Good governance is unglamorous until somebody tries to erase you. Then it becomes lipstick, armor, and a loaded briefcase. By the time the skyline had turned glossy and dark outside my apartment windows, I had reached a private, satisfying conclusion. If Ryan wanted me quiet, he should have chosen a woman who did not read the footnotes. I did not run to human resources. That department existed to protect Core Inc. from inconvenience, not me from executives with polished teeth. Expecting rescue from HR is like expecting a chandelier to stop a flood. Decorative, bright, and not built for that. Instead, I became methodical. I mapped every change to the acquisition memo and every person who touched it. I compared board deck drafts line by line. I noted the exact moment risk language vanished and who approved the edits. I reviewed the audit committee charter, the whistleblower policy, and the code of conduct booklet usually treated as office furniture. Then I called my Aunt Vina, a probate litigator with a velvet voice and the soul of a paper cutter. I told her the facts, not the emotional weather, just the facts. She listened and said what I needed to hear. If an executive suppresses material risk before a board vote and retaliates after you flag it, your protection starts with documentation, controlled reporting, and spotless conduct. No personal forwarding, no dramatic confrontations, no heroic emails written after midnight. Facts travel farther than outrage when they are properly dressed. Vina also confirmed what I already suspected about Slate Harbor. If a property transfer touches an invalid estate amendment, a trust beneficiary can challenge authority, lenders can question collateral integrity, and any buyer who claims ignorance had better have records to prove diligent review. In law, vagueness is not mercy, it is bait. I filed an internal whistleblower report addressed to the audit committee, not management. I attached my timeline, the red lines, and a brief summary of retaliation after protected reporting. I used the language of risk, process, and disclosure. I did not use the language of hurt. Pain may be true, but evidence gets invited into the room. Then I made a call that changed everything. The trust documents identified a contingent beneficiary named Cora, the late founder niece. I contacted her lawyer and asked whether she would confirm the estate status on the parcel at issue. No gossip, no conspiracy, verification. Cora agreed to meet me sometime in the late morning at a quiet cafe near the courthouse. She was practical, elegant, and visibly exhausted by men who spoke about her uncle's estate as though grief were an administrative nuisance. She brought copies of trust correspondence, a probate filing, and the unsigned amendment somebody at Slate Harbor had been using like a lucky charm. We compared notes. The amendment had never been validly executed. The parcel transfer relying on it was shaky. Slate Harbor leadership had pressured her to settle for a discount before the sale closed. She refused. I liked her immediately. When I returned to Core Inc., Rian was waiting beside my desk with the wounded dignity of a man whose prey had acquired teeth. "You are making calls outside your lane," he said. I smiled. "My lane is enterprise risk. You keep widening it for me." He told me to be careful. That line always amuses me when it comes from the source of the danger. By the end of the week, my bonus was still frozen, and I had been assigned a parade of trivial tasks usually reserved for interns and unlucky cousins. I assembled vendor notes. I reformatted presentation templates. It was petty enough to be strategic. Then an email arrived from Dana, the audit committee chair. "Please meet with me. Bring source documents. No cheerful punctuation. No assistant copied. Just clean authority." I wore navy, carried a binder, and arrived with the pleasant calm of a woman who had finally stopped trying to be liked by people whose approval was a tax on truth. Ryan believed he had pushed me to the margins. He had actually moved me closer to the witnesses' table. Dana had the stillness of someone who had spent years in rooms full of men explaining simple things incorrectly. She chaired the audit committee the way surgeons hold scalpels, with quiet confidence and absolutely no interest in improvisation. She asked me to walk her through the deal from the beginning, so I did. I showed her the property schedule, the deleted risk language, the trust dispute, the title defect, the shell entity holding the parcel, and the lender clause that could become a very expensive surprise if litigation escalated after closing. Then I laid out the retaliation: removal from the deal, restricted access, compensation interference, reputation whispers. I did not dramatize any of it. The facts were already wearing enough jewelry. Dana asked whether I believed the omissions were intentional. I answered carefully. "The pattern is not consistent with oversight." She nodded once. That was all. Then she asked the question that turned the room in my favor. "If you were advising the board, what would you tell them to do now?" I almost laughed at the beauty of it. Men like Ryan always assumed my value ended at spotting trouble. They never imagined I could also design the exit. I recommended an immediate pause on the acquisition, independent outside counsel to review title and trust authority, a fresh diligence memo delivered directly to the board, preservation of all internal communications tied to the deal, and an investigation into retaliation against employees who raised governance concerns. I also said the board minutes needed to reflect that material risks had been identified and evaluated before any decision. Minutes are painfully dull until a lawsuit arrives. Then they become a sacred text. Dana leaned back and studied me. You have done this work before. I have cleaned up after people who thought process was optional, I said. By the following week, outside counsel was in the building. Rian had developed a tight look around the mouth, and people who had ignored me now greeted me as if I were a small but meaningful weather event. Then my personal life handed me a second case. My mother called to ask whether I had told my stepfather, Kent, that he could handle paperwork tied to her rental duplex if anything happened to her. I had not. He had suggested broad authority while helping her sort family documents after my grandmother passed. He called it practical. Men often use that word when they want access to a deed. I drove to her house sometime in the evening and reviewed the papers. Kent had drafted a broad property management authorization from an online template. It would let him lease, refinance, and handle transactions tied to the duplex. My mother owned that property free and clear. It was her safety net. Kent had recently become fascinated by a restaurant investment that sounded like a collection of bad decisions wearing cologne. I called Vina from the kitchen table. She was direct. Absolutely not. A limited power of attorney can be useful if narrow, time-bound, and specific. Broad authority over real estate is how women lose control of retirement assets while being told they are overreacting. So I explained the difference to my mother in plain language. Who can sign? Who can borrow? Who can encumber? Why ownership, beneficiary designations, and trustee powers matter more than family promises. We discussed a revocable trust, successor trustees, and a plan that would protect her duplex without creating chaos if illness ever arrived. Kent tried injured innocence. I said trust is lovely, but title clarity sleeps better. My mother laughed, which annoyed him more than anger would have. At work, the acquisition vote was paused. At home, my mother hired Vina. Different battlegrounds, same lesson. Women do not need louder instincts. We need cleaner paperwork and less guilt. Rian still had his office and his title, but the walls around him were no longer solid. And I was no longer interested in merely surviving him. Corporate men unravel in elegant stages. First, they deny. Then they blame process. Then they become aggressively friendly, which is the most suspicious tone in business besides warm regards. Ryan reached that stage sometime in the early morning and invited me for coffee in a conference room with a skyline view. Glass walls, expensive chairs, and enough staged sincerity to upholster a theater. He thanked me for my dedication. He praised my attention to detail. He suggested that everyone had gotten emotional and that perhaps there had been misunderstandings on all sides. I almost offered him a medal for creativity. Then he presented a solution. Core Inc. was considering a new special projects role for me, broader exposure, direct contact with senior leadership, and a retention package after the current turbulence settled. In return, he wanted better alignment and less escalation. There it was. The silk-wrapped bribe. I asked whether the role would restore my frozen bonus and equity treatment. He said compensation details could be worked out. I asked whether he would correct the statements made about my performance. He said perceptions were complicated. Only for liars, I said. His jaw tightened. I told him any written offer would need review by counsel. Nothing disturbs a man with informal ethics like formal representation. I documented the meeting immediately and sent a factual note to the audit committee liaison. Retaliation followed by inducement is not a personality conflict. It is evidence wearing loafers. Outside counsel finished its preliminary review soon after. The findings were brutal in the restrained way lawyers enjoy. Material diligence failures, incomplete disclosure to the board, serious questions about authority over the parcel, indicators of retaliatory conduct. Slate Harbor transformed from strategic opportunity to flaming exhibit. The board removed Ryan from transaction oversight pending further investigation. Luke, the sleek executive who had replaced me on the deal, started walking around like a man who had just discovered loyalty is not a retirement plan. Then finance delivered a small, sparkling gift. A colleague I trusted mentioned that Ryan had personally pushed to delay my bonus while approving a generous consulting payment to a vendor tied to his former classmate. Not proof of fraud by itself, but enough to attract attention if linked to the acquisition work. I did not chase gossip. I reviewed authorized records, approval paths, and procurement exceptions available through my role. The payment had bypassed normal review thresholds through a justification memo so thin it could have floated. I sent one narrow question to outside counsel asking whether related party conflicts involving transaction support vendors were included in the review. Sometimes revenge is loud. Mine preferred a neat subject line and attachments. At home, my mother signed updated estate documents. The duplex moved into a revocable trust with clear successor authority and strict guardrails around any refinancing or sale. Kent was cut out of anything broad, permanent, or slippery. He sulked through dinner and called me controlling. I buttered a roll and said paperwork only feels controlling to people who wanted access without accountability. My brother nearly laughed into his plate. 2 days later, Rian was placed on administrative leave. He sent a company-wide email thanking everyone for their partnership and announcing that he was stepping back to focus on family and future opportunities. That sentence should be engraved on the wall of every office where truth has finally collected interest. I sat at my desk, opened my spreadsheet, and felt the odd warmth that comes when relief and justice arrive wearing matching shoes. Nobody had rescued me. I had protected my name, my work, and my mother because I understood something women are taught far too late. Money, property, governance, and control are never separate stories. They are the same story told in different rooms, and I had learned how to answer in all of them. Core Inc. paid my frozen bonus, restored my equity treatment, and offered me a new role reporting to the Chief Operating Officer with formal responsibility for governance and transaction risk. The company called it strategic restructuring. I called it a refund for inconvenience. I accepted on my terms. That was the delicious part. I negotiated written reporting protections, direct access rights for diligence materials, clear scope over acquisition reviews, and severance language triggered by retaliation or role diminishment after protected reporting. I requested a legal training budget, board presentation opportunities, and documentation stating that my performance record had not supported the prior compensation hold. The General Counsel blinked at that clause, then approved it. Women are often encouraged to negotiate in a grateful tone. I prefer a readable one. And I also hired my own lawyer to review every line before I signed. Pride is expensive. Counsel is cheaper. Cora reached a much stronger settlement with Slate Harbor once the sale stalled, and her trust claim could no longer be brushed aside as inconvenient family static. She sent me a note saying I was the only person in corporate shoes who spoke plainly. I kept it in the top drawer of my desk. My mother slept better after her estate plan was updated. Her duplex was protected. Kent gradually lost interest in discussing shared futures, once deeds, trustees, and authorization limits became impossible to wiggle around. Funny how romance fades when a woman understands encumbrances. As for me, I started mentoring younger women at Core Inc. Quietly at first, then with intention. We talked about equity grants, beneficiary forms, vesting deadlines, severance traps, indemnification clauses, powers of attorney, trust basics, and why every woman should know exactly who owns a property, who can borrow against it, and what happens if somebody gets sick before paperwork catches up. Charm is not an asset class. Understanding is. A few months later, Dana asked me to present governance reforms to a board subcommittee. I stood at the front of a polished room and explained diligence escalation, title review controls, conflict screening, documentation integrity, and the simple magic of making sure bad news reaches the board before it reaches opposing counsel. Halfway through, I noticed something satisfying. The room was listening the way people listen when they realize the young woman they nearly sidelined has become very expensive to underestimate. Afterward, Dana said I had a gift. I said, dryly? She laughed. Exactly. Sometimes in the late afternoon, I pass the glass room where Ryan used to stage his confidence. Someone else has the office now. The slogans are still on the walls because paint is cheaper than introspection, but the questions are sharper. The minutes are cleaner. The approvals are tighter. There is less swagger, more process, and a noticeable decline in men assuming charm counts as authority. I used to think power came from being chosen. Now I know it comes from reading the contract, tracing the deed, understanding the trust, spotting the conflict, and saying no with a steady hand. That is not cynicism. That is fluency. And in a world where so much harm hides in fine print, fluency can look an awful lot like justice with perfect timing. This morning, a new file landed in my inbox. Family-owned seller. Murky property history. Executive enthusiasm outpacing legal reality. I smiled and opened it. Some women inherit pearls. I inherit patterns. And patterns have made me extremely hard to cheat.